Alright, Bill Henshaw here again for the Constitutional Crisis Channel. This will be a brief video basically on the definition of interstate commerce for those of you that don't know. And it means a hell of a lot, two different things from one who's a strict adherent to the original intent of the framers of the Constitution than it does to these left-brain wackos these days. But in earlier times, one of the key cases is called E.C.Knight versus United States, 156 U.S. 1. And the court held in about 1895 that interstate commerce basically involved the transportation of goods across state lines. In other words, anything that was produced within a state at a production factory, whatever it was, it didn't enter interstate commerce until it went on the truck to be sent somewhere else. That was a hard and fast rule and a good rule to use. That's exactly the way it should be as far as I'm personally concerned. But we then get to the 1930s with good old Franklin Delano Roosevelt and his court packing plan that put the court under a lot of duress and coercion, threatening to appoint justices to assist all the justices over the age of 70, who just coincidentally involved the four horsemen who were voting against the bastard all this time, and they were losing the cases 5-4. Well, he finally broke through and got what's known colloquially as the switch in time that saved 9 by aptly named Justice Owen Josephus Roberts. And now the cases start to go 5-4 in his favor, one of the first of which was NLRB versus Jones and Laughlin Steel, 301 U.S. 1. Look this one up and read it carefully, especially the dissent of the four horsemen. Because now the court says anything that marginally affects interstate commerce falls within the ambit of Congress's Commerce Clause powers. This can't be right because they've also said in an earlier case called New Jersey Steam versus Merchants Bank, 6 Howard 344, that the Commerce Clause powers of Congress are closely associated with the Admiralty jurisdiction. The framers of the Constitution and the people of that time clearly understood Admiralty to be, quote-unquote, a jurisdiction foreign to our Constitution and unacknowledged by our laws. Declaration of Independence. This was one of the principal reasons for the American Revolution. King George III was continually using this jurisdiction to get his own way in the colonies and ignoring the common law rights of the citizens. That's what led to the revolution, and now here we are again doing the same damn thing 225 years later. So the long and short of it is, interstate commerce, the definition should be E.C.Knight versus U.S., not NLRB versus Jones and Laughlin. And it gets even worse in a little bit later case called Wickard v. Filburn, 317 U.S. 111, where the court went absolutely overboard in holding that the Commerce Clause powers apply to a farmer growing wheat on his farm. To this day, to my knowledge, there's only one case where the court has even attempted to limit the Commerce Clause powers of Congress. That's a very important case called United States versus Lopez, 514 U.S. 549. And read in particular the concurring opinion of Justice Thomas in this case. He gets it. He sees what's wrong. I think most of them do. But the left-wing wackos aren't going to admit it on the record. They want to keep the status quo as it is. I want to change it. We should want to change it. And if we do it right, we're going to get our way about it. Thank you.